Have a seat. Have a seat.
Man, you about to piss me off. Come on.
Welcome to one of the most heated eviction hearings we've seen on Bench Report Court Cam today. The plaintiff is pushing hard for nearly $4,300 in unpaid rent, while the tenant, Keir Fleming, fights back claiming she's been caught in the crossfire of rapid rehousing programs, job loss, and paperwork delays. But here's the twist. The judge is not playing around. Attitude, clashes, legal technicalities, and a courtroom on the edge. This case has it all. Stick around, because you're about to see how quickly frustration can turn into a judgment that decides someone's future housing.
Good afternoon, Your Honor. David Fantier on behalf of the plaintiff.
Your name?
Keir Fleming.
All right. Where are we on this case?
Ms. Fleming has a balance of $4,298.39. She indicates that she mailed the rental assistance form to the court on Wednesday.
She mailed it on Wednesday?
Yeah, I didn't know. I couldn't really hear you, but I thought you said mail it in, so I mailed it in.
Well, it needs to
Proof
be at
that
the court by
that I filled out an SIR with my tracker number and everything. I mean, an SER.
I don't have it.
Here's a key detail. Fleming has never made a single payment directly to the landlord. Instead, SOS, a rapid rehousing program, has been covering her portion. The issue: those subsidies aren't permanent. Once they run out, the tenant becomes fully responsible, and the landlord's lawyer is making that crystal clear to the court. Now, this raises a big question for you watching. Should a tenant be fully liable the moment assistance ends even if they're actively trying to find work? Drop your thoughts in the comments. Would you side with the landlord here, or do you think Fleming deserves more time?
Well, I sent it in.
Your Honor, I'll leave it up to the court what the court wants to do. I don't think her balance is $4,298.39. She's been on rapid rehousing with SOS paying their portion. She's never made a payment to my client. And I reached out, and from what she has said, so I reached out to SOS to see if they were going to be able to help her with the balance. What she indicated to
Anyways,
me.
can I talk? They're not going to be able to help. They're not going to be able to help with balance.
Ma'am. Let him finish, and I will hear from
I don't like.
You want to know what? You don't try to overtalk me, because that will never happen.
That's fine.
Am I understood?
Yes.
You know what? I'm going to pass the matter. You go down, check your attitude, and then I'll call your case back up.
Have a seat. Have a seat.
Man, you about to piss me off. Come on.
Whoa, did you catch that? The judge just ordered Fleming out of the courtroom after a heated exchange. In moments like this, demeanor matters as much as dollars. Judges expect respect, and any backtalk can tip the balance against you. It's not just about owing $4,298.39. It's about credibility, trust, and courtroom presence. And here's the dramatic part. Once a judge feels disrespected, every argument you make afterward can lose its weight. Do you think the judge overreacted, or was Fleming pushing too far? Let us know, because this is the kind of clash that can turn a case upside down.
Keep back talking. You better take that out of here. Oh, don't give me that look. Lee, get her out of my courtroom. Get her out of my courtroom. Court to pass that matter. Court does call the case of YPF 16 LLC versus Nakia Turner.
Your Honor, I'll wait for it.
That just messes up my whole day. Everybody else is going to have a hard time with me now. You know, I was in a good mood, and then it's just going to take one person. It just takes one person that just messed up my whole attitude. You know? Nakia Turner.
Your Honor, I filed an administrative closing on this case. I was able to verify with her bankruptcy attorney that there is a bankruptcy in both their names. Okay. And so I gave to...
and I will sign the order for administrative closing.
Great.
Got it. And YPF 16 versus Christina Morgan. That matter is dismissed on plaintiff's motion. And so we only have her?
Yes.
Do I want you to go get it? Not really, but I don't want to hold up Mr. Pantera. Tell her she can come back in now. You know, people, if she don't act right, it's gonna be get bad. No, hey, I'm just telling you. I'm just giving fair warning.
Would you like your coffee, sir? So we can go get it for you right now.
No, I'm good. I don't know about the rest of you, but I'm good.
We respect you, sir.
Your Honor, if you want to pass.
I'll pass it and then. No, you know what? You keep talking, I'm gonna do something to you too. Court cause the case, so Augusta Woods versus the Geraldine Ballard.
Good afternoon. Good afternoon, Your Honor. David Santa Croce on behalf of Shelby Mink. Oh,
Okay, got it. Is she in the premises or
so
Here.
her
YPF 16 LLC versus Kiera Fleming? Parties
Now that Fleming is back in the courtroom, the numbers are laid out clearly. $4,298.39 total, including court costs. This isn't just rent, it's months of missed payments adding up. Programs like SOS can only cover so much, and once they end, tenants often face a steep cliff. The plaintiff's strategy here is simple. Lock in a judgment before Fleming can gather more assistance. That's why these hearings move fast. The landlord wants possession, while the tenant is scrambling for time. Ever wonder why so many eviction cases end in judgments? It's because the financial math rarely favors the tenant.
Parties have returned. Mr. Pantera, you were in the middle of your statement, sir.
Yes, her current balance is $4,123.39. Court costs of $175 for a total of $4298.39. She's been in rapid rehousing where SOS has been paying her portion and she's supposed to pay the rest. She has never made a payment. I reached out to SOS. They tried to reach out to her, and it's my understanding that the rapid rehousing ends at the end of July. So in August, she's gonna be responsible for the whole thing herself. She hasn't filed a rental assistance form. I don't think it's a tribal issue. In fact, we would ask the court for a judgment.
All right, ma'am, what did you wish to say?
Anyway, like I was saying, SOS was paying my rent for 3 months without me having to pay anything. Like I told Miss Terry through SOS that I ended up losing my job, and I wasn't able to pay nothing at the moment. And I'm just now getting a job, and I wasn't able to pay nothing until today. But yeah, and I sent in my SER through the mail. I didn't know I had to come and actually bring it here. I don't have a car, so anytime I go anywhere, I have to get on a bus with my children. So I don't know if you're able to, if they bring the mail to y'all, but I definitely sent the SER to this courtroom with the judge with your name on it, Judge Simpson.
Did
But SOS doesn't stop. She said that I already filled the paperwork out yesterday when she came. They pay August, but after August, I won't be getting no more help from SOS. But I reached out to Hawk. They're able to help, and I did do an SCR with my caseworker, and I have an appointment with my caseworker on Monday for help, so I can get help with my rent. And I'm able to pay altogether $900 today, but that's all I can afford.
Well, if we get to August 1st, then August rent is going to kick in, which means you're not going to be.
No, August rent is paid by her, by SOS.
I'm going to let you finish because I'm not going to be interrupted again.
I'm sorry.
So what else did you want to say?
That's all I had to say. That's what I said. It was already paid. August month is already paid. That's why she came over yesterday and I filled out the paperwork. So August month to be paid. After August, September, I won't be getting no help after August, is what I'm telling you.
If SOS pays in August what they paid in July, it would be $650 on a $1,300 apartment, which would mean she'd be responsible for the other $650.
That's not true.
But even without, let's assume that for the sake of argument that SOS is going to pay the whole thing. She still has a $4,200 balance. And I don't think there's any way that's going to be paid. And she hasn't filed the form, even though, you know, the previous person heard you just fine last week when you said, we get it here within 5 days. It wasn't here within 5 days. We'd ask for a judgment today.
I did turn it in within 5 days. You said turn it in Wednesday, which I did turn it in Wednesday. And who is he to say that I won't have all of it paid? Like, you don't know that. I didn't know I can get as much help as I did until I reached out to all these companies. And I was unemployed for a while, which I just got a job. I just started working 3 weeks ago. So this is my first check. You have to wait 2 weeks in a hole to even get your first check.
Your Honor, I'm willing to extend the judgment, normally be the 28th. If we were to extend the judgment to August 4th.
This is the human side of eviction court. Fleming reveals she lost her job, only just started working again, and can scrape together $900 today. She's pleading for time, leaning on caseworkers and nonprofit programs to cover the rest. The landlord's attorney, however, argues that even if August rent is covered, the past balance still looms. This is where eviction law hits hardest. Intent and effort don't erase debt. So let's ask you if someone is actively trying to recover. Should the court give them more leeway, or should contracts and deadlines rule above all? Sound off below.
There's no tribal issue for this court in regard to this case. I'll grant a judgment court possession with the redemption amount of the $4,298.39 with the writ to issue August 4th, 2025. Thank you.
Can you tell me exactly what does that mean? So
I just issued a judgment, the 429839 will need to be paid on or before August 4th of 2025. I've done it that way because if I grant an adjournment in this case, quite frankly, whatever the dispute is with the August rent would be added on to this figure, which I was trying to say earlier.
Yeah.
So it's a benefit that if you can find the funds to get this paid, you only have to pay this amount. Does not include anything for August.
Okay.
All right. So you have to the 4th to get it paid.
Yeah, but last thing I got to say is that when I talked to my SOS worker, Miss Terry, our agreement was for her to pay the full amount because she know I'm not going to be able to pay the full amount. The money that I have now is going to be towards to the money I already owe. So August is already going to be paid. Like the full amount is going to be paid, so I won't have to worry about August.
Maybe you're not hearing me.
I'm hearing what you said.
The judgment. I'm not dealing with August.
I know that. I'm just letting you know for sure that's going to be paid. That's all. But thank you. Have a nice one.
Thank you.
Jesus.
Won't stop.
Nope, doesn't work.
And there it is, the ruling. The judge grants a judgment for $4,298.39, giving Fleming until August 4th, 2025, to pay in full. If she makes it, she redeems the property. If not, eviction proceeds. Notice how the judge carefully excluded August rent from the figure, calling it a benefitates, a subtle but critical detail. This case shows how quickly courtroom tension, financial strain, and strict legal timelines collide. What's your takeaway? Was the judge fair? Or could more compassion have been shown? If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.